Hi, friends. Good evening, and let us elaborate something on a very important topic, that is disqualification of members of the parliament, state legislatures, and members of municipality and panchayat. In fact, what prompted me to bring this topic is that our parliamentary system, which is based on territorial constituencies, in which members of parliament are elected on the basis of the territorial constituencies, and they represent the electorate in the parliament as their representative, and they are directly elected by the people. Now the question arises that if there are certain parameters and there are certain qualifications that has been stipulated in the constitution itself, and only when a person who is willing to become the representative is able to fulfill, then only he will be allowed to represent the people. So we know that a person who is willing to become the member of lower house must have age of at least 25 years, and in case of upper house it is 30 years. Apart from the qualifications, we must know what is disqualification as well. What is the disqualification? For example, suppose the court has declared a person of unsound mind, means demented, person is suffering from any mental ailments which disqualify him to become the representative of the people. Second, that if he is undischarged insolvent. Third is, suppose that he has acquired the citizenship of a foreign country voluntarily, or expresses his allegiance to a foreign force. In these situations, a person could be declared disqualified. But the last number, that is, if he holds office of a prophet, then under Article 102, subclause 1 and subclause A, a person who holds an office of prophet will be declared disqualified. Now, the question arises, why is it so? Dear friends, it is very important for us to understand. We have to go deep, delve deeper, that why a public representative is denied this. Suppose that you take your own case. You want to become MP, MLA, or member of municipality or panchayat. You fulfill all the criteria. But suppose that after being elected, the government makes you managing director of SAIL, GAIL, BHAIL, or any public corporation. And then imagine that the government introduce a bill, brings a policy which is detrimental to the people who you are representing. Will you be able to resist the bill, oppose the bill, raise your voice in the parliament for the sake of your electorate who sent you in the parliament to reflect their will? It is not possible because you are likely to be under the influence of the government. In such situation, there is a conflict of interest because you know that if I oppose, then I'm likely to suffer some loss. Therefore, this arrangement and provision was made in the Constitution that if a person holds office of profit, then he should be disqualified to become a member of parliament in upper house or lower house, or you know under 192, article 192 for the state legislature. Now the Supreme Court rationalized these views after the Ramakrishna Hegde. Ramakrishna Hegde in Karnataka was elected member of Legislative Assembly of Karnataka, and he was offered the job of Deputy Chairman of Planning Commission. He was reluctant, but then he accepted, and he wanted to protect himself. Therefore, he said that he is not going to receive salary, no remuneration at all. But he was getting some allowances like HRA, dearness allowance, convenience allowance, and some other allowances. Those may be said to be compensatory allowance. When the matter came before the Karnataka High Court, the High Court said that the office of the deputy chairman, in the case when a person is not receiving any remuneration for serving, will not come under the purview of office of profit. Later, in Jaya Bachchan case, once again this matter came, and the Supreme Court declared that the judgment in the case of Ramakrishna Hegde was not a good judgment. Why? Because even then he was getting some pecuniary gain, and the office of profit merely means that if a person is serving the government and in return he is getting some pecuniary gain. Now the amount does not matter, it is irrelevant. How much, that is irrelevant. But he is getting some pecuniary gain, maybe a car with chauffeur, free accommodation, free traveling, and all other allowances which he is entitled to get, he is getting, and he is receiving all the benefits, but he is saying that I am not receiving any remuneration. Even then, the Supreme Court said that these allowances, perks, and benefits will be declared to be a pecuniary gain, and you are definitely getting some profit, and therefore it was declared very well office of profit. In a very important case, Madhukar and Jaswant in 1976, the Supreme Court rationalized the view by saying that several people with the specialized degrees like doctors, engineers, teachers, lawyers, and etc., other people also are eager to serve the country in the capacity of being a representative of the people, but they are not able to come and join just because of the Office of the Profit Act, because they are serving in some capacity in the government sector, and therefore this rule inhibits them to come and serve the people. So there must be a balance. The Supreme Court very aptly strike the balance that every services must not be brought under the office of the profit, and by that precluding the good people from coming into the politics. And at the same time, we have to maintain that there should not be any conflict of interest. So it was said that a committee was also formed by the Parliament in 2006, that is Office of Profit Act Committee, in which there are 10 members from the Lok Sabha and 5 members from the Rajya Sabha. And in day-to-day working of the Parliament needs to sometimes establish certain ad hoc committees, certain permanent committees, some statutory agency, etc. And therefore, it is indispensable and inevitable as well to bring some people of qualification in that post and designation, and they need to serve there. How can we deny that if the person is holding a post in the government should not have the representation or capacity of representing the people? Therefore, in order to strike the balance, the Parliament established this committee so that before we delve into the deeper, we assign the job to a particular person. We need to find out whether the particular designation will come under this uh, definition or not. Now, what should happen if the person comes under the office of profit? Out of these all four essential ingredients of disqualification, that Article 102, subclause 1 and subclause A, states that if a person holds, so what are the ingredients? The person must hold the office of profit, and that office of the profit must be under the central or state government, and he has been declared by so. Now, suppose that he has been declared. What will happen? What is the procedure of disqualification? And who is the authority, ultimate authority to decide whether the person holds office of profit and he should be disqualified? So, Article 103 in the case of the members of parliament and Article 192 in case of legislative assemblies, legislature, it has lays down the procedure that it is the governor in case of legislature, state legislature, and president in case of parliament. These both authorities are going to decide, and that there is a very important statement which I'm going to make, and mark my word that he does not and they do not have, means the governor or the president, they do not have to consult council of minister for this decision, but they will refer this matter to the election commission. Election commission will inquire into the matter and then will give its opinion to the Supreme Court or governor, and then they are bound by the decision taken by the election commission. So it is merely the announcement, final announcement of the disqualification, which is done by the governor and the president, but they are bound to accept the decision. Now, one another matter, in case of Jayalalitha, when Subramaniam Swamy, uh, you know, represented before the governor that she was holding office of profit. At that time, in 1993, T.N. Session was the chief election commissioner, but at that time it was one member election commission. Later, it was made 2 members. Supreme Court said while deciding the disqualification, the election commission acts as a quasi judicial body, and therefore they must follow the natural justice. And one of the essential ingredients of natural justice, like Audi alterum partem means the person must be given the right to represent himself. Another is that if the election commission somehow or other finds himself in a situation where he is somehow or other related with the person, must recuse himself from the committee. So TN Session was the chief election commission at that time, and his wife, he was represented by the Subramaniam Swami's wife in certain cases. Therefore, Jayalalitha brought this case before the Madras High Court that he must recuse himself. Now, dear friends, today I'm going to tell you one thing, that my lecture will be in both Hindi and English, because I want both medium student should comprehend this. This is very important, chapter of our constitution. And office of prophet has been in the limelight for a long time, and therefore I thought that I must discuss this, before you. तो आज के लिए इतना ही, लेकिन आगे से जब भी मैं कोई नया चैप्टर लाऊंगा, so I assure you that I will discuss. Right now I think that this is very important, and for that matter I think that you can understand this, कि किस आर्टिकल में, ये आर्टिकल सब कुछ मैंने लिखा हुआ है इस पर, और आपको एक्सप्लेन कर दिया है कि जनप्रतिनिधियों को किन किन मुद्दों पर डिस्क्वालीफाई करने का अधिकार दिया गया है, उसमें प्रेसिडेंट को और गवर्नर को, और इवेंचुअली ये अनाउंसमेंट, ये घोषणा की जाती है कि फला रिप्रेजेंटेटिव को डिस्क्वालीफाइड किया गया है जस्ट बिकॉज ही इज होल्डिंग द ऑफिस ऑफ प्रॉफिट. एंड आज के लिए इतना ही, and that's it. And once again I will come with a very good topic, especially for those students who are preparing for the competitive examination, and especially the UPSC students. So that's it for today, and thank you very much.